And in the meantime, time is running. Somebody has been arrested and they've been held for days and days and beyond the 72 hours, most of the time.
Jamono bobu sax day waxtu wa ngay gëna dem rek nit ñu ko japp tek ko benn place lu jéggi li nga xamné lolu lu amé di ñetti fan.
And one important right for any person who is arrested by the police is to have access to a lawyer.
Ben ci yelle fi nga xamné nak amna solo lol ki nga xamné dañ ko japp pour momi tamé mëna am ko xamné lawyer la bu ko taxawal.
Yeah, that's right.
Waaw lo deug la.
How often would such right of access to a lawyer be either denied or delayed in cases in the 4 categories that you've mentioned?
Oh, almost all.
Naka la daan faral di amé jamono jo xamné nak borom amna yelleef pour mëna jot ci lawyer ñu ayé ko ko wala ñu yixal ko naka la daan faral di amé.
Almost always.
Danaka dal waxtu wu ne la toujours.
Can you give us a few examples of this denial or delay of access? By citing cases that you can remember off the top of your head. Sorry for putting you on the spot on that, but seeing that it happens almost always, perhaps it may not be difficult to remember one or two.
Mun nga ñoo jox yenn ci misal ben wala ñaar ci yo xamne war nga ko mëna fataleku comme ka lu daan faral di am la xejna du ñak yo xamne mu ci sa xel mi ba légui.
Yes, there are many. I mean, I'll begin with my senior, Mariam Denton. She is the doyen of the female lawyers. The doyen, she was the first female lawyer. When she was arrested in 2006, we tried, I personally, we tried to see her. It's just an example of the denial of access, but even though this one didn't happen at the police station, it was at Mile 2 Central Prisons.
Comme rek pour seet nag li wax nag li nga xam ne ni mu ngi aju ci wàllu ni nga xañee lu jëm ci mbiri lawyer ndax bii amutoon ci police station yi waaye mu ngi woon ci kaso gu mag yi Banjul Mile 2.
Which I can speak about a bit later, perhaps. Another example would be Lamin Tunkara.
Loolu nag danaa ci mën a wax ci gannaawaan kanam tuuti waaye beneen bi mooy Lamin Tunkara.
Who was arrested along with the, well, what I later understood to be a group of West African migrants.
ñu ngi ko jàppoon nag ñeneen ñoo xam ne nag mujjee gi laa xam ne daal ay doxandeem yoo xam ne nii ñu ngi jóge ko ci diwaani Afrique sowu jant.
I wasn't initially denied access to him.
ca njëlbeen nag ayewuñu woon ma nag pour ma gisanteeg moom.
But when I went back with the court order for his release,
waaye bi ma demaatee nag ci ànd ak ndigal boo xam ne nii pour mu ngi tukkee ci court bi pour ñu bàyyi ko.
I saw him.
ma gis ko.
And but the police wouldn't release him.
waaye nag police yi nangu yoon koo bàyyi.
They kept saying that such and such senior officer, OC is not here. Just basically.
dañ daan nekk rek di wax naan diw ak diw kenn kilifa nangam daal di joxe ay lay rek.
Until suddenly they said he was no longer there.
ba mujjantal gi ñu mujjee wax ne daal nekkatut fa.
I have had colleagues arrested also.
am na ay suma yeneen nawle yoo xam ne jàpp nañ leen.
Held at either the police station, because here they usually would sometimes be at the police station, sometimes at the NIA.
ñu dem téye leen ci police gi fii nag léegi ci police ga wala sax ci buntu liggéeykaay NIA.
But sometimes in these cases, the way the police received you.
waaye fii nag léegi ni nga xamee noonu la police di dalale.
Sometimes you could see that they were trying to do their job, but were constrained.
léegi nag dafay mel ni sax ñu ngi def seen liggéey waaye nag ci ak ay jafe-jafe.
But what do you think constrained them, either based on what they have told you or what you have observed?
nga foog ne nag loolu moo leen dee tënka ci niñ la ko dee waxee la wala yow ci sa seetlu boppa.
Oh, I've had officers, because some of us had good relations with some of the police officers, and they would tell you, really, I want to help you. I want to give you access to your client, but I can't. I have orders not to.
waaw léegi daal xam nga am na yenn police yoo xam ni sax am nañ jokkoo bu rafet léegi dañ lay wax ne la bëgg naa laa wane leeg sa client bi de waaye nag amoon ndigal bi.
Because they would always say they were still investigating.
ndax mujjee dañ lay wax rek ne la ba léegi rek ay mbiram ñu ngi koy gestu ba tey.
And they considered giving the lawyer access as, you know, interference.
te ñu lay ñuy gisee rek ne buñ la joxee jotaay pour nga gis sa client bi rek moo nekk ne dangay dugal sa loxo ci gestu bi ñooy gestu.
What's the problem here? Is it lack of knowledge on the part of the police that, in fact, allowing lawyers to, or allowing clients, or sorry, suspects to confer with their lawyers is part of the investigative process? Or is it just blatant denial of access on the basis of instructions they may receive?
ban la ci nag ndax ñi nga xam ne ñooy police yi ñàkk xam-xam boo xam ne am nañ ko ci ne ki nga xam ne moom lañ téye dafa war a gisee ak looyaam te loolu bu ko defee dafa mel ni ñu ngi dugal loxo ci gëstu bi wala boog dañ tey teelu rek bañ rek pour ngeen gisante ak seen
I think it's both.
yaakaar naa ñaari yëpp la.
I'll give you an example.
naa la jox benn misaal.
This happened at the prisons.
lii mu ngi xew na ci kaso gi.
When my clients, I went there to see Bailo and others.
ci jamono bi nga xamee nag suma client yi benn dem naa pour gis Bailo ak ñeneen.
My instructions were that they were in detention, incommunicado for almost 2 years.
ñoom nag ñu ngi leen téye ci benn place boo xam ne nii duñ war a gisanteeg wala wax ak kenn fii diiram ñaari at.
I went to the gates, and as soon as I gave their name, they're usually very cooperative, but as soon as I gave the names, they looked at each other and then they referred to senior officers.
waaw ci njëlbeen nag danañ jee ànd si wax ji de waaye nag boo tuddee tur rek ñu xoolante rek commencé di la ebal ci ay kilifa.
I waited while they consulted with their seniors.
ma toog di xaar waxtu woo xam ne ñu ngi wax ak seen kilifa yi.
And then they referred me to one of the commissioners of prison at the headquarters.
ci booba nag ci lañ ma ebal ci kenn ci police commissioner si kilifa yooyu ci seen makkaan gu mag gi.
When I went, he received me very well.
bi ma demee nag mu dalal
I
bu baax.
had fairly decent rapport with all of them.
amoon naa jokkoo bu rafet ak ñoom nag daanaka.
As soon as I mentioned, he said, "What do you want, counsel?"
mu laaj ma nag loo soxla counsel.
As soon as I mentioned the names,
bi ma tuddee tur yi rek.
he said, "Oh, no, you can't see those people."
ci la ma di mënuloo gis ñooñu.
No, those people have nothing to do with the court.
ci la ma wax ñooñu nag amuñ dara loo xam ne ñu war nañ koo jëflante court bi.
He was trying to educate me.
mu ngi mel ni ku may jéem a jàngal.
He said to me, no, those people are detainees.
ma ne ñu jàpp teg leen benn place la.
They are not remanded by the court here.
ñoom nekkul ñoo xam ne ni court bi moo leen fi teg.
I said, yes, I know they're detainees.
waaw xam naa ne ñu jàppale.
Was that a suggestion that detainees are not entitled to access to lawyers?
Definitely.
Well,
and he further explained. He said these people are brought here from the top, from the executive.
ci la gën a leeral sax ne ñii ñu ngi leen agsi fii rek ci ndigal lu jóge ko ca kaw.
I said, yes, I know. I'm here to see them as their lawyer.
ci la wax ne waaw dama ñëw fii pour gis leen ne maay seen lawyer.
One thing that became very clear during our institutional hearing on the prison was the fact that such detainees were admitted to prison without any single document or authority. Was that your experience?
Nga xamne nak mom lañ jot ci CD bi ñoo gëstu mbiri liggéey kay yi lañ jot ci walu prison bi moy ñi nga xamne ñom lañ fay tiyé du am ben kayit sax bo xamne lu aju seen mbir la bo xamne nañ ko fay.
Certainly, he confirmed that to me.
Loolu la wéral ci man.
But he thought that was okay. That was the worrying thing about it. He thought it was okay. You know, it's like, okay, you only hear, lawyers are only allowed to see those that are going to court or likely to go to court, but not others, as though they were just entrusted to them to keep till whenever, and they will hand them over to whoever entrusted them to.
Would you agree that such a system was a good platform for enforced disappearances of people.
nag foogul li nga ànd nag ci ne façon yi doxalin boobu noonu dafa ubbil bunta rek pour jékki-jékki ñi nga xam ne dañoo jékki-jékki rek ne meles kenn du leen gis.
Certainly, because there was no account for those people that were there.
Again, for these prison officers, is it your experience that they acted in that manner purely out of lack of knowledge, purely as a result of that they did not know the applicable rules, or was it just blinded implementation of orders they may have received from above?
ndax yow ci sa wàlli gis-gis ñi nga xam ne ñooy liggéey ci prison bi ñoom ñàkk xam-xam la rek pour doxal li nga xam ne loolu la yoon wi laajte wala ñoom dafa doon loo xam ne rek kàddu gu bàyyeekoo ci seen kilifa yi moom la ñoo jëfee.
Certainly, it was lack of knowledge.
waaw loolu daal di ko lal yëpp mooy ñàkk xam-xam rek.
Because of the way he spoke to me.
ndek ni mu doon waxee ak man.
It showed me that he was completely ignorant of what the law required.
But
it also showed me that he was terrified. Even consider letting me have access. So it was convenient for him to just say that.
David Colley testified before the commission, and he suggested that for these security detainees, the prison officers had no control over them. They had no authority over them. Their role was to just keep them. Did your experience suggest that fact?
David Colley ne ñooñu nga xam ne ñenn ci ñiñ jàpp foofu la ñoom ñiy liggéey ci prison bi wala prison bi foofu amuñ benn kàddu ci seen kaw dañ leen ñëw rek dénkal leen ko pour ñu dencal leen ko ndax yow noonu nga ko gisee.
Yes, I agree, because that is precisely what the prison commissioner told me.
waaw nangu naa ci loolu kañ ndax daanaka loolu sax la ma prison commissioner bi wax.
Apart from the problem of access to suspects in whose cases the president had interest, what are the other problems that you have encountered, say at the level of the police with regards to such type of suspects?
Gannaaw jafe-jafe yi ngeen di am nag pour mun a gisee ak seeni client yi nga xam ne président bi am na aajo ci ay mbiram yan yeneen façon yi jafe-jafe ngeen di faral di am ci ñooñu.
Well, if they eventually grant you access,
gannaaw boo xamee ni sax jox nañ la pour nga gis ko.
They would literally be standing over you as you consult with your client.
dañuy taxaw tiimu la gannaaw boo xamee yaa ngi waxtaan ak sa client.
They won't allow you even private consultation?
No. They would literally be standing over you. And sometimes we'd ask them to move, but you had to work with what you had. It meant going without seeing the client. You will just manage.
dañuy taxaw tiimu la de léegi-léegi sax dañ dee sàkku si ñoom pour ñu dem waaye duñ ko def léegi li ngay def rek mooy ci ak ñàkk pexe rek nga jël li nga xam ne loolu nga ca am wax ak sa client.
Some have testified here and talk about the issue of bail, that one of the biggest problems is the issue of bail. Was that so that your experience?
Am na ñu fi joxe seeni seede tam wax nañ ne ñoom bokk na ci jafe-jafe yi ñu daan am mooy mbiri bail ndax yow tamit loolu dal na la.
Yes, in numerous cases.
Waaw ci ay case yu bari.
What methods would they normally use to frustrate bail applications?
Ci lan lañ dee sukkandiku nag pour yaaxal li nga xam ne moo di bindu yuñ bind pour ngeen sàkku ñi ñu am bail.
Well, they thought that as long as they say that they're still investigating, that justifies continued detention without being taken to court.
waaw léegi-léegi bu fekkee ne wax nañ ne de ñoom ba léegi ñu ngi gestu loolu moo wéral rek ne daal ba léegi rek dañ koy teg benn place ba jamono bu ñuy dem court.
isn't there a realization in the police that the whole essence of denying bail should be, or rather denial of bail should be premised mainly on the flight risk of the person and no other consideration? Or the possibility that if this person is released, the person would destroy evidence that is available.
Ndax doonut yëg-yëg rek ci police bi ne borom buñ ko bàyyee xëj na dina daw wala mu yàqa li nga xam ne moo di seede yi ñoo war a soxla ci wàlli gistu bi.
Well, that ought to be the consideration, that ought to have been, but it wasn't. In these cases, I mean, as I said, in ordinary cases, there's no problem there. Almost always they would either charge or release after the 72 hours.
waaw léegi de ci noonu la war a nekkee de waaye nag comme su fekkee ne case boo xam ne nii case yu ordinary la rek ñaare da ngaa gis rek ñu teg ko ay tuuma yu ñu ko war a teg tuuma wala ñu bàyyi ko balaa ñetti fan yi.
But in cases in which there was interest.
waaye nag ci yenn case yi nga xam ne nii dañ ci am aajo.
They wouldn't release.
duñ la bàyyi.
And that distinction is very clear, that the way they proceed with cases in which Jammeh had interest was completely different from other cases in which there was no such interest.
Certainly.
Loolu firnde gi set na dinañ koy nangul yeneen case yi waaye duñ ko nangul ñi nga xam ne Yaya Jammeh moom itteem a ngi ci loolu.
How about the issue of torture?
Nakan mbiri mitital yi nag.
In police stations.
Police station.
We would come to that with regards to the NIA and other institutions. But your experiences with the police. Have you encountered instances of torture?
I have had some clients, not many, that have alleged being slapped, etc., but not at not the severe forms of torture at the police station. However, that's from my personal experience. However, I had a matter, I believe it was Samba Doroba, that alleged severe torture at the hands of the police. I think he gave evidence before this commission of acid being poured on his private parts.
Fanna yu dëppoo yooyu ci mbiri police bunti police yi am na client yoo xam ne nii dañ leen tawal rek ne comme dañ leen mbéj waaye nag nekkut comme métital yoo xam ne nii yu jéggi dayo.
Not that that is not serious.
waaw yoo xam ne nii métiwul noonu waaye nag
nekkut ne loolu duwut lu garaaw.
waaye nekkut lu garaaw waaye am naa ci benn ci client koo xam ne nii Samba Doroba moom nga xam ne nii wéral na fii sax ne dañ sotti woon asib ci ciram.
You recall, Mr. Chair, Samba Doroba testified before the commission. I think the alleged perpetrator was Modi Pikajalo, if my recollection is right. Yes. So yes, we do have that information.
Yes, but most of the severe tortures happened at the NIA.
At the NIA.
Lu bari nak ci yu metti tal yu muy amé ci NIA.
But also in terms of frequency of torture, was it rife at the police or was it not? Based on your experience.
Faral di amé ci wàllu métital dina amé ci police ba wala du fay amé yow ci sa wàllu yëg.
In my experience, it wasn't rife.
Ci suma yëg nak du doon bari non.
It wasn't rife because most of these suspects didn't spend too much time at the police. That's what I think.
Ndax lu bari nak ci ñu japp dal duñ daan yàgg ci loxo police.
Okay. Other than how about the issue of remand? Because police prosecutors were generally responsible at first brush in dealing with some of these cases. How was the issue of the issue of remand dealt with? Well, it's the corollary to bail, but perhaps I should revise the question. The issue of holding charges, how was it dealt with by the police in cases in which the executive or Yaya Jammeh had an interest.
Naka lañ daan jëlee nag ca police ba pour dal di teg nit ki li nga xam ne moom lañ ko tuumaal ci ñi nga xam ne ñu ngi leen fa téye te bi fekkee na Yaya Jammeh am na ci itte ñoom naka lañ daan jëflante ñoom ci mbiri bail.
Well, they will use it whenever they need it to sort of buy time.
dañ ko daan jëfee saa bu ñu ko soxlaa ngir rek ngir a yaatal waxtu wi.
And they were in the habit of even charging in the wrong court.
léeg-léeg sax dañ koy def nag jikko ko di ko teg ay tuuma ci court boo xam ne duut court bi mu war a dem.
And then hope that the magistrate would remand until they're ready to file at the High Court.
ci kaw yaakaar boo xam ne rek ne magistrate bi.
It was abused.
dana ko remand ba jamono boo xam ne dañ ko toxal ci court bu gën a kawe.
And we understand, or we've received evidence suggesting that the executive did not hold too kindly to magistrates who would not comply, especially in cases where they're interested in. And the example that is cited is the case of Said Matiba, Jau, who was not in fact that one. Yes, Said Mati too, that happened. Said Mati was acquitted. But for the purposes of holding charges, there is this instance of, say, present-day Justice Jaite, when he was a magistrate. A person was charged before his court in Birkama. He believed he did not have jurisdiction, and he released the guy and asked that the case be taken to Bundung Court, which had jurisdiction. He was subsequently arrested and detained for doing that. Was that kind of experience, was that kind of situation common?
With lawyers, you mean?
No, with say, magistrates and so forth.
Yes, it depends. As I said, it depended on the case and whether there was interest in it and whether the magistrate would play ball.
waaw wax naa fi rek comme ni ma ko waxee kon mu ngi des rek ci li nga xam ne ni ñoom am nañ ci aajo ak nga seen ndax magistrate bi dana ànd ci seen kàddoom déet.
I don't have personal experience, but it was commonly known that some of them received instructions.
amuma nag ci boo xam ne nii jëflante la ci man waaye nag am nañ ci yoo xam ne nii yëg-yëg ne danañ daan jot ndigal.
As to whether or not they should grant bail.
ndax dañ war a grant bail wala déet.
We would come back. We would come back to that.
Sorry, we keep going back and forth. But
yes, we'll come back to that issue when we talk about interference, because perhaps maybe that forms the one of the most significant aspects of interference in the independence of the judiciary. But let's now talk about the NIA with regards to this problem of access, torture, denial of bail, and things like that.
léegi nag ñu ñëw ci mbiri NIA ci nga xam ne lawyer nañ ci jotee seen client yi wàlli bail ak yu mel noonu.
Well, I've never been allowed access to my client, any client that was detained at the NIA.
mosuñ ma may nag yoon pour ma gisanteeg suma benn client boo xam ne nii ñu ngi ko téye ci NIA.
Have you had clients detained at the NIA?
mosoon nga am ay client yoo xam ne ñu ngi leen téye NIA.
Yes, I can cite an example of a colleague that was there.
Waaw mën naa cee wax sax benn ci may nawle yoo xam ne mu nga fa woon.
And we tried to, myself and Mrs. Sagar Jahate tried to see her, and we couldn't. We were denied access.
Man nag try fexe woon naa man ak Mrs. Sagar Jahate pour gis ko waaye daal ay amee ñoom ñu gis ko.
On one occasion, because I persisted, and one occasion I went and I was allowed in for the first time.
maa ngi fàttaliku benn jamono sax de demoon naa bañ may nañ ma dugg.
I saw the DG and the deputy, Sen, I believe, and Sen and Yankuba was then Yankuba Baji was then the deputy.
ma gis fa nag kii borom kër gi ak ki ci topp Sen ak Yankuba Baji yaakaar naa jamono boobu moo toppoon ci kii jiite.
When I was allowed in, I had high hopes that I would see her. I'd been there for over a month.
biñ ma maye nag ma gis ma dem yaakaaroon naa sax ne dinaa ko gis ndax boobu mu fa woon su dem si dira benn weer.
But eventually they said investigations were still going on, and I could not have access. I was disappointed.
Mom nak after mujjé gi nak ci lañ ma wax rek na ba légui ñu ngi def ay gestu kon mënu ko gis ma mon ci ak tas yaakar nak.
We will ask the same questions of the NIA. Did those officers you spoke to, did they have knowledge that or information that the client, that the suspect or the detainee had a right to speak to you as her lawyer?
Malajar la rek la mala lajon ca police ya ndax NIA ñi fa nekk di liggéey ñoom am nañ xam-xam bu mut pour xam ne lawyer bi dafa war a gisee ak ki nga xam ne moo di clientam biñ téye.
I believe they did because they were senior.
Waaw yaakaar naa ko ndax ñoom ay kilifa lañ woon.
But in spite of that, they decided to refuse access.
Yes.
Ak liñ ko xam yépp terewut dañu tere la pour nga gisante sa client.
Yes. They didn't confirm that she was there. But they didn't deny that she was there either.
Weddi wuñu ma digalu nit ne mu fa waaye nag weddi wuñu ni tamit ne mu fa.
And I remember at the time Council Jobate was also being detained there with some other people.
Council Jobate moy bo mu fa ak ñu japp ko ak yeneen nit.
When he was suddenly brought to court, I was in court, Banjul Magistrate Court, in another case.
Biñ indi nak ci court ci Banjul Magistrate Court bo ma ngi won fofu.
Before he was taken away, he spoke to me and said, "Nene, we saw you the other day when you came. Please just insist." She's there. Insist on seeing her.
Ci la ma balañ ko yobbu ci la ma gis mu ne ma Nene gisoon nañ la kéro bi fa ñëwé continuer rek dingatal rek mu ngi fa.
From what we have heard so far in this commission, it appears that the NIA would consistently deny detaining people in whose case the executive had an interest.
ci li nga xam ne day moom lañ fi jotagum fii ci ay seede mu mel ni waa NIA yi dañuy continuer rek di bañ ñu mun a gis ña nga xam ne ñu ngi leen fa jàpp te fekk nag ñi nga xam ne ñoo di kilifa yi ñoom ñu ngi ci am itte.
dañuy bañ a nangu ne ñu ngi denc ñeneen ñi ci seen place su fekkee ne nguur gi amoon nañ interest ci ñooñu seen case.
Yes, yeah, that is right. That is correct. Because if they, in fact, getting through to the gates was a problem, as I said, just the one-off that you'd allowed in. So they would never confirm at reception whether the person was there. Well, so you wouldn't know.
Ci fi nga xamne moy daluway ba sax lay fofu duñ la fa mësa nangul sax ne la mu ngi fofu ci jamono bu.
Yes.
But for much of these cases in which the executive had an interest, from your experiences, where were they more dealt with? Was it at the police or at the NIA?
ci ñi nga xam ne nag ñaareel kilifa yi dinañ ci am aajo lool fan lañ leen dee faral di teg ci NIA wala ca police ba.
Certainly the NIA.
lu ci bari daal ci NIA gi la ñu gën a leere. And
it looks like there is one common thread, some common standard that happened in most of these cases. For all cases where the executive is interested in, there is denial of access at the police, at the NIA, and at Mile 2, at the prison. Correct?
dafa mel ni daal yëpp ay nuroo ci benn anam bi yëpp lañ dee jëflante ak képp koo xam ne téye nañ la te fekk kilifa yi ñu ngi ci am aajo noonu lañu ko defee ci police ba di ko defee ci NIA ak ci prison bi tam.
That is correct.
loolu la.
How about the treatment, physical treatment of the person who is arrested and detained at the NIA? What have you learned about such people?
lan nga jànge ci façon nit ñooñu nag naka lañ lee jëflante ak ñoom fekk ñu ngi leen téye ci police bi wala ci NIA.
Oh, I've had many that have alleged torture before confessions are drawn out of them.
am naa ci tawat yu bari yoo xam ne tawat nañ ne dañ leen daan méttital balaa ñooy wax ne li nga xam ne nii loolu lañ leen tuumaal ne ñoom def nañ ko balaa ñu koy nangu.
Could you give us examples?
jox ñu misaal.
For example, the 2006 attempted coup, the suspect Two suspects.
Ci misal ci atum 2006 ku fomm bi nga xamne ni amon na fi amna ñaar ño xamne ni dañ leen ci tuumalon.
That was the Captain Bunja Dabo and others.
Bu moy Captain Bunja Dabo ak ñeneen.
Ndur Cham.
Ndur Cham.
And which individuals in particular alleged torture?
Ñan ci ñom la wax ne dañ leen do mitital.
Well, they were tried, the soldiers were tried at the court-martial at Yundum Barracks, and all of them, without exception, alleged torture at the NIA.
There were
about 10, I believe.
Soldat bi di court-martial bi ci Yundum Barracks, waaye ñoom ñëpp dañ tuumawoon dañ waxoon ne daal dañ leen doon mettital.
I have here a report by Amnesty International entitled Gambia Fear Rules.
Mangi am fi nak kayit bo xamne Amnesty International ñoko bind ci mbiri Gambia.
And it concerns this case that you're talking of. Part of it concerns this case that you're talking about. And since you participated in the trial, I'll read this out and you tell us what your observations are. And it's alleged torture in the course of treason trial.
Under
the general topic of pre-trial confessions under torture. And Amnesty started with this general statement that torture is used routinely in Gambia to force confessions and as punishment.
Ne mitital day mom dañ koy faral di jëfoo rek bi réewi Gambia pour ñi nga xamné ñom lañ bëgg ñu wax wala defal leen ko lo xamné dañ leen ko mbugalé.
In both the military court martial and the treason trial,
ci ñaar yépp ci atté kay bi nga xamné moy atté bi ñoo fa ñoo atté soldat yi ak ñi nga xamné ñom la ñoo atté né dañ doon suufu nguur.
Significant evidence surfaced to suggest confessions had been extracted under torture during the pre-trial period.
Amna sédé yu bari yo xamné feñ na woné né dañoo mitital seeni borom pour mun leena wax lo jamono ji nga xamné ñu ngi leen di layo.
Raising concerns about the admissibility of the evidence.
Lolu nak itel nañu pour mëna xam anam yi nga xamné non la ñoo joté sédé.
What's your view on that?
No, gisé lolu.
That is very accurate.
Nek na lo xamné lu jub la.
And you said earlier that almost all of them claimed that they were tortured.
Wax nga fi ci gannaaw sax ne danaka ñoom ñepp woné nañ ne dal dañ leen mitital.
Did you participate in the trial at the High Court of the non-soldiers who were prosecuted?
Bokon nga ci layo bi nga xamne ñu ko doon def ci High Court ci ñi nga xamne duñ soldat te ñu yobbu won leen ci atté kay ba.
Yes.
Wow.
I believe there were two. I'll say two because Hamadi Sow was extracted from the other lot. He was concealment of treason. For some reason, they wanted to discontinue the case. So he was extracted, so I took him, I was his counsel separately. So there was the bigger trial of Ali Job and others, which I was not part of. But I defended Hamadi Sow against the 2 charges of concealment of treason at the High Court. He was a civilian. He's a civilian.
Hamadi Sow mom civilian la te man mako don baddu di kiko taxawalon ci court bi. Ci ñaari tuuma ne dafa nëbbutu noppee loo xam ne nii lu jëm ci wàlli suufu nguur la.
Aliou Job and Serigne Omar Fall, they both testified before the commission. They also alleged that all of them were tortured.
Aliou Job ak Serigne Omar Fall ñoom ñëpp joxe nañ seen seede fii te ñoom wax nañ ne ñoom ñëpp am na ay mitital yoo xam ne teg nañ leen ko.
And counsel, they just didn't allege, they actually sometimes showed us injuries that haven't quite healed or have healed, but you can tell when the scar is new.
Counsel, emuñu woon rek sax di tawat ne dañ leen daan métital waaye léegoo-léegi sax dañu daan won gaañu yoo xam ne nii wér nañ wala wéraguñ bu baax wala ay légét yoo xam ne ni bàyyi nañ ko ci métital yooyu.
How about Hamadi? Was he also tortured?
Naka Hamadi nag moom tamit métital nañ ko.
He was. I think one of his teeth was broken, one of his teeth.
Waaw ndax benn ci bëñam sax dañ ko damoon.
Yeah.
Would you say that torture was basically a common feature for a lot of the cases, politically charged cases, that were dealt with at the NIA, from your experience?
Ndax ci sa wàlle gis-gis yi nga mun a wax ne daal mbiri mitital ak mbugal yi dañ koy jël di ko teg ñi nga xam ne ñu ngi leen téye ci seen mbir loo xam ne daal mu ngi ànd ak wàlli politique.
From my experience, more in that treason case, in the attempted coup d'etat. I think they were perhaps a bit more ruthless because there were other cases in which there was state interest, so to speak, but there wasn't so much of the allegation of torture.
Man ci suma gis-gis li nga xam ne ni nag mooy tuuma yi ñu leen defal di tegoon di tuuma suufu nguur fa lañ daan gën a ñàkkee yërmande fa lañ daan gën a soxoree ci seen kaw.
I just want to say that it wasn't all cases in which they had interest that torture is alleged, but definitely in that 2006 attempted coup, almost all the suspects alleged severe beatings and severe torture.
Nekkuma di wax rek ne daal ci yi nga xam ne ni amoon nañ ci aajo amutoon métital waaye nag bu 2006 coup bu fomm bi noonu boobu daal moom ci lañ leen daan gën a métital yu gën a soxore.
Have you participated in other treason trials apart from the 2006 coup attempt?
Gannaaw coup 2006 bi ndax bokkoon nga ci beneen layoo boo xam ne mu ngi aju ci mbiri suufu nguur?
That was earlier in my practice. I came in and found my senior defending Uncle Dumo Saho. That was Ibrahima Barrow, the state and Ibrahima Barrow case.
Mooy jamono bi nga xamee ni commencé na ci wàlli lawyer rek suma kilifa gi jamono boobu mu ngi doon taxawal Dumo Saho di ci kiisi Ibrahima
Barrow, the state and Ibrahima Barrow and others.
Ci diggante réew mi nguur gi ak Ibrahima Barrow ci tuuma boobu.
I believe himself and Mamadou Dumo Saho and Marena.
Yaakaar naa ci Mamadou Dumo Saho ak Marena.
That is the case in which Kasso is involved.
Foofu nag ci la Kasso bokkoon.
And in that case, was torture alleged?
Ci jamono boobu nag ndax amoon na ay mitital yoo xam ne tegoon nañ leen ko?
Yes, it was.
Wow.
Mr. Chair, Ibrahima Barrow testified before the commission, and he did describe gruesome torture that he went through, where he was stripped naked and before the NIA leaders, including Usman Sow, and where he was tortured by Alhaji Moore, he said.
I don't know whether he actually also informed the court of when he was removed from Mile 2, taken to NIA, and threatened to change his confession? Okay.
Yes. Were those the only treason trials you worked on?
Yes, those two. Yes.
In a sense, it looks like all the treason trials you were involved in. Let's put them in three categories. The first one, that is Ibrahima Barrow and others, Hamadi Sow, and the Bunja Dabo and Co. All that said, they were all tortured.
Yes.
Mu ngi mel ni yow ci layoo yi nga bokkoon yépp ci mbiri ñi doon jéem a suuf nguur ñoom Ibrahima ñoom Hamadi Abunja ñooñu ñépp am na ay mbugal yoo xam ne teg nañ leen ko.
We have had in 1997 the Farafenni attacks. They were tortured.
Dégg nañ ne atum 1997 conga googu ñu daloon ca kaw Farafenni ñooñu tamit am na ay mbugal métit yoo xam ne teg nañ leen ko.
We haven't dealt with the attack in Kartong.
Waxuñ mbiri conga ga ca Kartong.
But the 2006 Ndur Cham, they were tortured.
Waaye 2006 coup d'état Ndur Cham boobu ñooñu tamit métital nañ leen.
The Ibrahima Barrow treason 2000, those two were tortured.
Atum 2000 bu Ibrahima Barrow ba ñooñu tamit mitital nañ leen.
What's his name again? Landing Sane in 2000, they were tortured.
Landing Sane atu 2000 momit mitital nañ leen.
2009 Langtombong crew, they were tortured.
2009 bu Langtombong ba ñooñu ca bokkoon tamit mitital nañ leen.
And 2014 December attacks, those arrested were also tortured.
Atum 2014 weeru December so nga xamne mo xewon ci diko way bour ba ñooñ tamit mitital nañ leen.
Council, correct me if I am wrong here. Does it not appear that torture was basically a state policy to be applied to people who are arrested and accused of treason?
Jaajante ma na bu fekkee ne juum naa waaye nekkul ne nag lii lu daan faral di am la ñi nga xam ne dañ leen day jàppat leen tuumal suufi nguur daal ñoom saa yu nekk rek dañ leen daan teg ay mbugal yu miti.
I would agree.
waaw danaa ci ànd de.
And sometimes the clients would tell you words that were uttered as they were being tortured.
léegi nag client bi sax dana la day nettalil kaddu yi nga xam ne nii moom lañ ko dee wax jamono bi nga xamee ñu ngi ko doon mbugal.
Such as insults and asking them why they hate the president and why they want to do such and such. So
léegi di ay saaga ak di ko laaj lan moo tax ngeen bañ président bi ak yeneen ak yeneen.
And some would even say that they had instructions to do what they were doing.
te tamit ñenn ñi sax dañoo wax ne am nañ ndigal pour def li nga xam ne nii loolu lañ doon def.
This is from the clients.
lii nag mooy loo xam ne nii wax ju tukkee ci client yi la.
We would come back to how the issue of torture or allegations of torture have been dealt with by the courts, especially with regards to confessions that have been extracted as a result of this torture.
Dinañ ñëw ci mbiri mitital yi mbugal yi nga xam ne ñu ngi ko teg naka lañ ko daan jëlee ci attekaay yi su fekkee ne joxe nañ fa ay tuuma ne am na ay mitit yoo xam ne ñu ngi leen ko doon teg.
So let's talk about Mile 2 prisons.
Léegi ñu wax ci mbiri Mile 2 ca kaso boobu.
We have touched upon it, upon that issue as we discussed the other subjects, but let's just come back to it.
Laalool nañ ci tuuti rek bi ñoo waxtaane yeneen fànn waaye nag ñu dellu si waat ci rek.
Especially on the issue of access and general treatment of detainees.
Surtout ci ni nga xam ne ni ngeen ko mun a jotee seen client yi ak ni nga xam ne daal noonu lañ daan jëflante ak ñañ fa téye.
Yes, generally, I didn't have any problem going into Mile 2 to see clients.
Actually,
I had a fairly good rapport with most of the officers, including David Colley. But in instances when you know, for example, in treason cases, which they took very, very seriously, they would sometimes obstruct.
Can you give examples?
Well, there are instances when they would give you some excuse or another, come back tomorrow, come back day after, particularly where in the initial stage of the detention. And to my mind, over the years of experience, I've come to know that that is to perhaps allow time for the suspects for my clients to heal, for example.
To heal from what?
To heal from alleged tortures. So that was usually a reason for stalling the lawyers having access to our clients at Mile 2.
To allow
that's my personal opinion.
To allow for cover-up of the terrible crimes they have committed.
And it often resulted in them, if necessary, disobeying court orders. They will do that just to buy time.
léegi nag ñu dal di bañ tamit ndigal loo xam ne mu ngi tukkee ci code bi loolu yëpp pour dàq waxtu rek.
In your statement, you cited few examples, Raif Diab, Counsel Mariam Denton, including your own father, with regards to denial of access.
Ci sa kàddu yi joxe nga fi ay misaal Raif Diab ak it Mariam Denton nag sa papa sax yow ci sa boppa ne bañ nañ pour ngeen egg ci ñoom gisee ñoom.
Yes, fortunately for them, my father and Uncle Raif Diab, they were only there for a month.
Suma papa nag ak Uncle Rams Diab ñoom ñu ngi fa woon rek ci diira benn weer.
But not a single time was I allowed access. I or any other lawyer allowed access to them.
waaye nag amul ci benn waxtu boo xam ne ni may nañ ma gis ko wala beneen lawyer ñu may nañ ko mu gis ko.
It took about 5 days after detention for them to even be allowed change of clothing, the two of them.
jël na sax lu dem ci juróomi fan gannaaw bu ñu leen jàppee pour ñu may leen rek ñu wecci mbubb yi ñu soloon.
And these were elderly people.
tey ñii ay mag lañ woon.
For my colleague, she was in there for 3 months.
waaye nag suma nawle bi moom mu ngi fa woon lu dem ci ñetti weer.
And despite court orders for her to have access to her counsel, they repeatedly turned us away.
sax day ndigal loo xam ne mu ngi tukkee ci court bi pour mu am jokkoo ak lawyer bi loolu yëpp daal dañ ko doon di bañ.
I believe it took over a week before, because I would go there every day with the court order for the release of Mariam Denton, and I would be turned away.
yaakaar naa dem na su dem si diira benn bés bu ay bët bu set rek maa ngi dem foofu ak court order bi ndigal bi tukkee ci court bi waaye ba léegi rek dañ koy bañ.
How about the UDP or the protesters of 2016?
naka nag ñi nga xam ne ñoo doon def ñaxtu boobu ci atum 2016.
I believe the same happened.
yaakaar naa lépp benn boobu rek moo xew.
In fact, after Mr. Dabo and others were arrested and detained, I believe the following day, after, yeah.
yaakaar naa jamono bi nga xamee ne jàpp nañ Mr. Dabo ak ñeneen ci beneen bés bi rek.
Myself, Mrs. Mendy, Bori Toure and Senior Counsel Mr. Antuman Gay went to the PIU headquarters.
man si suma bopp ak ñeneen ñi nga xam ne ñoom la tudd noonu yëpp di ay kilifa ci lawyer dem nañ ci police PIU bi.
We were led, I believe it was the Sunday or Sunday or Saturday. We were led by Mr. Gade because we heard that of what had happened and that many of them were injured because the videos were out, them being beaten up in the streets.
ndax ki ñu jiite woon na mooy Mr. Gade ndax jamono boobu nag vidéo yi wisaaroo nañ ci nit ñi yëpp di seetaan gis ne daal li xew de dañ leen doon dóor si mbedd mi.
But we were not, we were denied.
waaye nag nangu ñoon ñu gis leen.
And the Solo Sandeng case, also the women who were involved, the women who were arrested and tried, did you have access to them?
ci mbiri Solo Sandeng nag jigéen ñi nga xam ne jàppoon nañ leen yóbbu leen ci court bi ndax mënoon ngaa gise ak ñoom.
Oh, I think their situation was even worse.
yaakaar naa boobu sax moo gënoon a garaaw.
Tell us about it.
wax ñu.
In fact, it took a few adjournments for them to produce them in court after the case had come to court.
bi mu àggee nag si court bi sax de jël na ay aj yu bari yenn aj yoo xam ne nii am na balaa ñu naay feeñal sax si court bi.
The men were there, but the 3 women were not in court for about 2 to 3 adjournments.
góor yi ñoom ñu ngi fa woon waaye yeneen jigéen ñi ñoom ñëwuñu woon lu dem si ñaar ba ñetti aj yoo xam ne ni aj nañ court bi.
Yes, and their names were on the charge sheets.
te seen tur mu ngi woon ci charge sheet bi.
And when they eventually were brought to court, you can visibly see the pain that they were all.
te jamono bi ñu leen indee ci court bi mun ngaa gis si sa bët méttit yi nga xam ne ni daal daj nañ ko ci.
That was Fatoumata Jawara, Fatou Kamara and Nogoy Njai.
boobu mooy Fatoumata Jawara, Fatou Kamara ak Nogoy Njai.
And Fanta Dabo.
ak Fanta Dabo.
And did the case, was the case tried in Banjul?
Case bi nag ndax ñu ko doon layoo ci Banjul.
They suddenly, out of the blue, transferred the case, I believe, to High Court Mansa Konko.
mu jéegi ci lañ dal di toxal case bi ca court bu kawe ba nekkee ca man sa konko.
Was that normal?
ndax loolu dinañ faral di am.
Very abnormal indeed.
nekkul lu jaadu de.
What was the impact of the transfer of the case to Mansakonko on the issue of access to lawyers?
lan la indiloon nag toxal boobu ñu ko toxaloon foofa ca Mansakonko lan la jural nag pour lawyer yi mun a gis ci ñoom.
Well, given the fact that most of the lawyers are in the greater Banjul area.
All
of their lawyers.
Lawyer yi bari dal ñu ngi dëkkee fii ci Banjul li ko wër.
And us, the lawyers who were representing them, were here.
te ñun ñi nga xam ne ñoo nekkoon lawyer yi leen doon taxawal ñoom ne ñu ngi woon fii.
Already attending to two or three other groups of the same, arising from the same incident.
doon teew na ci ñaar yoo xam ne ni ay képp lañ goo xam ne ñoom it lu mel noonu lañ leen tuumaal rek.
Mr. Dabo's group.
Group bi Mr.
Second group, Maud Sarr's group, the third group, and the other women also.
di ñaareeli groupe bi bu Maud Sarr ak ñeneen ak yeneen groupe.
So it was difficult, if not impossible, for any lawyer to go up there.
dana daan jafe lool pour lawyer mën a dem foofu nag.
So they went unrepresented.
so kon nag looloo taxoon ñoom kenn du leen daan taxaw.
And for a case of that nature, for the accused person to be tried without a lawyer would be a big travesty of justice. Would you think?
A case bobu ak ni mu tollo muna ayé borom pour mu gissé ak lawyer bon lolu mel na ni xagnañ len li nga xamné modi.
It was contrary to the provisions of the constitution.
Nek na lo xamné da deppowut ak xaté buntu luwaay réewi Gambia.
Because treason carries the death penalty.
Ndax suufu nguur nak man nañ la atté sax né dañ lay rey.
For which one is entitled to be, must be represented by counsel.
And where one did not have counsel, it was the responsibility.
Sorry. It wasn't the treason, but yeah. I just
the charge wasn't.
The charge wasn't. Yeah.
All right. Okay. All right then.
But they were entitled to have legal representation.
I mean, the transfer of the case by itself amounted to denial of counsel because it made it basically impossible
yeah.
for lawyers from here to go there to try to defend that case.
Effectively.
Wow.
And in fact, not just their lawyers, but their family members also.
In your statement, you talked about the case of KM, a child who was detained at Mile 2 prisons.
Could you
tell us more about that?
Can I just conclude on the last point?
Please, go ahead.
I just forgot to say that I actually went to Janjanbureh prisons where they were being detained, the women, after their case was transferred, and I was denied access to them.
ñaan na rek pour mu jekkali fànn bi mu doon waxtaanee mu ne dem na nag ba kaso gu mag gi nekkee ca Janjanbureh gannaaw boo xamee ne nii seen layoo bi ñu ngi ko toxaloon Mansakonko waaye nag ba léegi it may woon ko pour mu gisanteeg ñoom.
I went there and I was given one excuse after another because they had to get clearance from above and above and above all the way from Banjul.
mu ne demoon na fa nag waaye nag dañ ko doon layal rek ndax boobu ñu ngi doon ut ndigal yoo xam ne mu ngi jóge koo ci kaw.
Because we were very concerned, we heard of the dire health situation. It was afterwards, after the case had finished, concluded that I saw Fatou Kamara and she reminded me of that. I didn't know that they could hear me also, similar to what happened at the NIA. Because the premises were very small, but you didn't know where they were, but they could hear me. To asking for them, and she said that gave them hope.
Dal wax na itamit ne gannaaw nag loolu ci la gisanteeg Fatou Camara tey tamit nag mu ne am NIA tuuti na de waaye ñoom duñ leen dee gis waaye nag ñoom dinañ dee dégg moom ngi wax ak lu jëm ci seen mbir te loolu nag yaakaarloo na leen lool.
I can go to, sorry.
Yes, go ahead, go ahead.
No, I was going to go to your question now.
But
just before you get to that, exactly how many cases were transferred to Janjanbureh and how many to Mansa Congo?
I believe, no, Janjanbureh is the prisons where they were being detained because it's closer to the court.
Sure.
Yes. And I definitely know of the Solo Sanding group where the women were. Mutsar's group, I don't know whether they were actually in Banjul or it was a very, that time. I'm surprised I can remember a lot.
Also, some of the men were also transferred to Janjanbureh prison,
yes.
But their trial were being held at Mansa Congo High Court.
Yes.
So they would travel, they will commute to court. You recall we had one of the witnesses say that their pickup truck constantly broke down.
Yes.
I see, yeah.
Yes.
Okay, fine, thank you.
Yes. So this experience of denial of access was not limited to just you, I believe. Quite a lot of lawyers in private practice also had similar experiences, wouldn't you say so?
Linga hamne dañu ayé lawyer ñu gisante ak seen client yi emuton ci yow rek de dal na lawyer yu ci bari ñoo xamne ñu ngi liggéeyal seen boppa ndax déet.
Yes, because we had one thing in common. We were defending clients that the state didn't want.
Did the Bar Association do anything about this?
Mbootaay lawyer yi nag ndax ñoom def nañ dara ci mbir moomu.
Well, it was the Bar Association members who were representing. Are you talking in particular about this case?
No, the Bar Association take this issue up, the issue of denial of access, as one main problem in the criminal justice system.
Ndax mbootaay lawyer yi ñoom ekati woon nañ mbir yi itteewoo ko wane ne pour aaye lawyer ñu mun a gisee ak seeni client loolu dafa yàq li nga xam ne moo di àtte gi ci biir.
The Bar Association did. I believe you had my learned senior Mr. Tambadou here yesterday.
Yes, indeed.
Bar Association bi def nañ dara ndax dégg nga rek démb suma genn kilifa Ba Tambadou doon wax fii.
I would like to corroborate what he said because part of that time I was a member of the executive of the Bar Association.
Dama gën a dëgëral rek li ma wax ndax jamono boobu bokkoon naa ci kilifa yi nga xam ne nii ñoo seqoon mbootaay googu.
When Mrs. Bensouda, particularly when Mrs. Bensouda was president.
Ci rawatina jamono bi nga xam ne Mrs. Bensouda moo nekkoon président.
Letters were written, I mean, any kind of protest that lawyers could have done maintain their dignity, we had done.
Bind nañ ay leetar ak mboolem ñaxtu boo xam ne nii lawyer yi mënoon nañ ko def rek pour nag mën a saxal nag li nga xam ne nii moo nekk seen daraja waaye.
Let me ask another very broad question. Would you say that there was a state policy to torture suspects in treason cases?
Ndax di nga mëna wax ne amoon na benn sart boo xam ne dañ ko tëral pour nag nguur gi war di mitital ñi nga xam ne dañ leen téye te tuumaal leen suufu nguur.
From the experiences you have.
Ci yow daal ni nga ko gisee.
Sure, from first hand from my clients.
Waaw ci lu njëkk nag ci suma client yi.
And it is my belief because that is what I saw and lived. And that is my belief is that it was a state orchestrated thing.
Ci li ma gis ndax loolu dund naa ko gis naa ko itamit.
And a policy, yeah, why not? Because it happened routinely in all of these cases. So.
Di sarta ndax li mu ngi xew rek ci case yi nii ñu koy faral di def rek.
And we were made to believe that they were acting on instructions.
Itamit dañ ñu gëmloo woon rek ne ñoom ñu ngi dox ci ay ndigal.
And they genuinely believed that it worked.
Itamit gëmoon nañ sax ne mu ngi dox.
Because they managed to obtain the confessions.
Ndax mu danañ daan mën a am nag li nga xam ne nii mooy nanguteeg.
Which when it gets to the court.
Boo xam ne bu àggee ci court bi.
The court believes.
Court bi danañ gëm ne.
Uses it as basis for conviction.
Te itamit sukkandiku ci loolu loo xam ne dañ leen mën a àtte tëj leen.
It was as simple as that.
Noonu rek la yombee woon.
We would come back to the issue of how the courts dealt with the issues of illegally obtained confessions. But in the meantime, You did say that they acted on instructions. Would they tell you where these instructions came from?
Well, they say from the top. Sorry, interpretation.
Dinañu ñëwaat nag ci mbir yi li nga xam ne noonu la ñoo fexe ba seeni borom nangu te àndut ak luwa.
Well, they will tell you that they were acting instructions from the top.
waaw dañ la dee wax rek ne ñoom ñu ngi doxee ci ndigal loo xam ne mu ngi jóge ko ca kaw.
And where do you understand or what do you understand the top to mean?
Well, they never mentioned. They never mentioned the former president, but you know, my belief is that everything came from him, because if you lived in this country, you knew that nobody else dared do anything else. It couldn't have been anybody but him, and if it was anybody, it would have been on his instructions. That is my belief.
naam duñ daan tudd turam de waaye nag soo nekkee fii ci réew mi war ngaa xam ne tamit ne de su moyee moom kenn ñemewut sañuta def yu mel noonu.
Now let's go to the case of KM.
Yes.
léegi nag ñu ñëw ci mbiri KM.
Oh, now that case, okay. After Mrs. Mariam Denton's case,
Mrs. Denton,
which the female lawyers of the Gambia came together and defended her, I believe 2 to 3 months after that, we thought we needed to form FLAG, Female Lawyers Association Gambia.
Under
the leadership of our seniors, Mrs. Bensouda, Mrs. Aida Drame, and Sahawasise Sabali, and others. Janet Salanjai. And so that we could take care of the welfare of our members, one. Promote the welfare of our members and also offer free legal services to women and children. Particularly those who couldn't afford the services of a lawyer. So we did that in that summer. So there was a time when I believe whether it was the judiciary and the AG chambers personnel went to visit. I remember I think the Chief Justice Ajim was there, and Marley Wood, State Council. They went and paid a visit to the prisons.
Chief Justice Ajim Mumfon ak Mali Wood.
It was a routine. I wish we could have more of those visits.
They
discovered that there was a young girl there who was about 17 who was never taken to court. And so when they came out, Mrs. Wood, who was instrumental because she's from Ghana, she was a state council and they had FIDA Ghana. So she was very active. The FIDA, that is the equivalent of Female Lawyers Association in Ghana. So she brought it to our attention that there was this girl in there. So we decided to take it up straight away under the leadership of Janet Sala. Myself, I believe myself and Mrs. Sagar Jahate went to visit her. And when she came out and saw us, she sat down. It took her about 2 to 3 minutes before she could talk to us. She was weeping. Her eyes were welled up and she was crying. It could have been more than 3 minutes. We were all emotional, and I felt that spoke for itself.
She
didn't have to tell us anymore. Because here was this child who got all her rights violated. This has nothing to do with this has nothing to do with the state or any interest. This was just an ordinary, a terrible lapse, shall I say. She was 17, still a child. She had spent over 2 years in prison. I believe for a few months initially at Janjanbureh because the incident had happened up country. Then she was taken to Mile 2 where she spent most of the time. Until we saw her. So almost over 2 years in detention without ever being taken to court. Yeah, of course, she was not charged with any offense. She was accused of having killed her husband. I believe she got married at the age of around 13. Before that, and she was being held in an adult prison. Contrary to the provisions of the Children's Act and the Constitution.
Under the Constitution, could she have been lawfully married at 13?
No.
Did it?
Well, that's another issue.
That's another
the subject to personal law bit comes in and...
the Constitution overrides personal law.
But the children, yes, but the Children's Act is specific.
Is specific.
Yes, and with the amendment that was made in 2016, I believe, it specifically now makes it unlawful.
Makes it unlawful.
2016
The earlier law kind of, it was against the earlier law, but this one is more specific. It makes it a crime now.
Exactly. Okay, good. So how did that case end?
Yes, we filed case documents, filed processes in court right away for a habeas corpus writ to be issued. So that they can bring her out and produce her to the court first. Yeah, it was Mrs. Njai, myself, Mrs. Jahate, and Ms. Faraj, I believe. And she was brought and subsequently released unconditionally by Justice Almamital. But counsel, what was just unbelievable was that there was no trace of the police file even. The State Council had to apply for an adjournment to try to liaise with there was no file.
State Council
So here's this young girl who was arrested, beaten up, taken to prison for over 2.5 years without even a charge or even a police file.
Big
lapse in the way the system was working.
We have seen a lot of violations here. We have heard about a lot of violations, but at least in most of them there would be a case file.
Gis ne ya haluwayu ci bari nak waye nak yi ci upp yeb ñaarel dinaay am file bo xamne ci lañu binda mbiri case.
This one had no case file.
Well, they couldn't produce it.
They couldn't produce it.
Because after she was produced, the court granted her bail.
To
her father. Her father was there. And then we went further to the court to declare the arrest, the detention, and the whole works unlawful.
ci lañ fexe continuer pour nag ci court bi ñu déclarer jàpp beeg téye beeg teg benn place bi yëpp ne la dëppawut ak yoon.
So it was during that period that the State Council was trying to find out, because they had no idea, and this girl could not be accounted for anywhere.
ci kaw loolu nag ci la State Council bi commencé nag di daw ak dikk si ngir seet xale bi amul fan foo xam ne nii fi lañ bind ay mbiram.
Wow, that was a serious lapse in
That
this.
was serious. I know that I personally took it upon myself to advocate for, actually after that case, I had a few other cases in which as soon as they remand the girls in mile 2, they were removed and taken to the shelter, because that is what the law says. They should not be detained together with adults. And you get told that we don't have the facility. At least you have Joshua for the boys, but you don't have anything for the girls. And so that is serious.
So did you take it a step further by asking for compensation for the unlawful detention?
Ndax am nga yeneen jéego yoo xam ne na jëloon ngeen ko ci pour laajte ndàmpaay pour xale bu jigéen boobu ngir téye biñ ko téye ak liñ ko def te benn àndu ci ak luwa.
We didn't, because the father was just happy that he's got the daughter back and didn't want any, in fact took her far away.
defuñ ko nag ndax baay ji daal kontaanoon na rek ne jotaat na doomam ci jamono boobu.
I asked this question because it would be interesting for the commission, at least if that person were to file a complaint with the TRRC for the violation of her rights.
Okay.
Waa dama laajte loolu nag mooy dina itteel TRRC bu fekkee ne xale boobu dal dina binda pour joxe tawat ne dañ yàq li nga xam ne moo di yelleefam.
The father kept in touch for some time, but then I've lost touch with him, but he knows where I am, so maybe he's watching and he can come forward.
Bayam nak dañ daan jokkoo waaye mujjee gi daal jokkoo bi dog na waaye nag moom xam na fi ma nekk te xëy na sax mu ngi seetaan nag ci jamono ji.
Mr. Chair, perhaps this is a convenient time to stop for the first break, and we would come and try to finish before lunch.
Yeah. So she went with her father. She was not taken to the shelter, was she?
Léegi dafa ànd ak papaam yóbbuwuñ ko fi nga xam ne fa lañ leen denc xale yi.
No, she didn't get to go to the shelter. After the writ was issued for her production to the court, yes. That's how she left mile 2. And then she was unconditionally released, so she went home with the father. There were subsequent cases in which young girls had been taken to remand, and upon protest, I know I protested, they've been removed and taken to the shelter to be detained there because they were accused of murder, yeah. Which was not bailable.
And was there a monitoring system in the shelter?
Can I just say that eventually I managed to get all of them bail. There was not much there. Mm-hmm. There was not much there, but they were aware that these children were there in the custody of, under the custody of the court.
Thank you very much.
But I got them, the two that I had, I got bail as soon as possible because the Children's Act allows that.
Indeed.
For that, even if you're charged with murder.
Good. Thank you. We'll take it 30 minutes.
That's an important exception.
Yes.
Indeed.
Yes, very important.
We will take a coffee break and come back at 12:30.
Okay.
Thank you very much. Meeting is adjourned.